All right, well, with me now to further discuss this fellow at Heritage Foundation, Cully Stimson. Hi, Cully. So first off, let me ask you about everything that we're seeing unfold today. Going back to these notes where these FBI officials, we see these conversations being had among these top officials. Peter Strzok, Comey, Obama was in the room. What do you make of all of this? Are some of these top officials in the Democratic Party essentially implicated, and what does this mean for Joe Biden's campaign moving forward?
Well, look, whenever there's exculpatory information or information that tends to undermine a prosecution, and clearly these notes did, especially with respect to the charge he pleaded guilty to, had that information been given to his first set of defense lawyers, they wouldn't have advised him to plead guilty because, in fact, he wasn't guilty because the statements he made were not material to a perjury charge. And so whether there's egg on the face of the Obama team, that's a political decision, and I'll leave that to the viewers to decide. As a legal matter, though, the prosecution and only the prosecution, the executive branch, there's a separation of powers issue here. Only the executive branch gets to decide whether to prosecute somebody, and I've been a prosecutor at the local, state, and federal level, and only the executive branch gets to decide to dismiss a charge or withdraw those and say, look, there's no there there. We didn't know there's this other evidence out there, and therefore it's not the interest of justice to let this go further. We move to dismiss this. And Judge Sullivan is a judge. He's in a separate co-equal branch of government, but he put up a roadblock to that, and that he was slapped down by the appeals court for doing that.
Well, and based on how Judge Sullivan has handled the case leading up to this point, do you foresee him coming forward and accepting this ruling and ultimately dropping the case, or do you anticipate some other sort of roadblocks, some wrench that he might be throwing into the mix here soon?
Look, he's a trial judge. I was a trial judge. Sometimes you get overruled by the appeals courts, and when you get overruled, you salute and say aye, aye, and you carry out the order of the day. And the order of the day is dismiss the charges, judge, and move on to the next case. So he can either accept that, like most trial judges do. They don't like it, but they accept it. Or he can cause a fuss, and he does like to speechify from the bench, which I suspect he may take advantage of when he dismisses the charges. Or somebody could ask for the full court, the en banc D.C. Court of Appeals, to take up the decision of the panel. And if that's the case, then this case will drag on for a period of time.
Well, this ruling today also raises questions regarding a lot of these other cases that sort of sprung up from the original Mueller probe. Do you foresee today's ruling having any sort of future implications on these other cases that have still yet to be resolved, like Roger Stone's case, for example?
I don't see any connection between a sole legal issue, and that is who has the right to dismiss charges and what is the role of the judge when even the government, the prosecuting arm of the government, says there's no there, we move to dismiss, and the defense agrees. The dissent is very interesting in this decision, but it misses the mark. And what I like, and I think a lot of law students and other just general citizens who aren't thinking about the law every day, they should read the opinion. It's really short. It's a good primer on the separation of powers, the role of the government and the prosecution's branch, the role of the judge in their narrow lane that they can exercise discretion in when the government tries to move to dismiss charges. You don't want to live in a society where a judge can say, you know what, I know the government doesn't want to prosecute anymore, but I want to look into their decisions. You can't look under the curtain of the executive branch decisions of whether to prosecute or whether to dismiss a charge. That's not the role of the judge.
Well, and something that does stand out to me, because I've seen a lot of people talk about this, and they point out, a lot of people are quick to point out how Judge Rao is a Trump appointee and Wilkins is an Obama appointee. But what stands out to you about Wilkins' dissent in this, and how do you compare that to the majority opinion?
Well, number one, the majority is the majority, and so they're right, and the dissent is a respectful voice in opposition, but it will carry no weight to the majority opinion. The majority opinion also, point by point, goes through and refutes the dissent, which in a lot of cases, the majority opinion doesn't take on the dissent and knock it down for what it is. I think the opinion. The opinion is rather narrow, and it's carefully reasoned, and it basically says a writ of mandamus, which is what this was, is called for in extraordinary circumstances. This is extraordinary because we don't want judges second-guessing the executive branch decision to bring charges or to dismiss charges when they say it's not in the interest of the public, or there's newly discovered evidence, which happened. Both of these were the situation in this case. And so it's a very narrow decision. I think a lot of people are trying to make political hay out of this. I don't do politics. I just do law and policy. It's a very narrowly crafted decision, and it won't have any effect on these other cases related to the Russia probe.
All right, so we'll still have to wait to see some of these decisions be made separately from today's big surprising ruling, but certainly making waves through D.C.